The question that people ask me often is employment law relevant to my business? And for most people, the answer is yes. It's relevant if you've got full-time employees, obviously. It's relevant if you've got part-time employees. It's relevant if you've got contractors, because they might not be contractors, they might be employees. And it's relevant if you've got workers. And by workers, you heard me talk a bit earlier, I mean people that are sort of casual workers, people that are on 0-hour contracts. It's still relevant. They're not entitled to everything that an employee is entitled to, but they are entitled to some things. So they might not be able to claim unfair. She's a troublemaker. I'll go to this. Okay. So a 0 hours contract is, I don't have to give you any work and you don't have to accept any work, but we've got a relationship. So Sports Direct, been in the news a lot, they use them. McDonald's use them. A lot of people in the holidaying industry, because you wouldn't want to have somebody on a contract to say work 20 hours a week if you don't know from one week to the next whether or not you're going to have enough people. So we'll have a quick guessing game. Barbara's not allowed to answer. Barbara's a HR consultant. How many different types of claims do you think an employee can bring against an employer? I've worked in businesses before where there was one lady who found somebody literally in her till, and another one who found that the employee had been using her credit card. And how do you feel as an employer when you found that out? You feel like saying, get out and don't come back ever again. And don't ask me for a reference. That's how you feel. But you can't do that. Even if you have caught them, even if you have seen them with your own eyes, you need to take them through a process. There's a 3-stage process. It's an investigation, it's a disciplinary hearing, and possibly an appeal. You always have to offer an appeal. Whether the employee takes it or not is up to them.
The contract or a statement of employment, do they have to sign it, they've read it, or do you give it to them?
They don't have to sign, they've read it.
Okay.
What do you think happens when you get to a dispute and they don't like something that's in the contract?
They'll just say they haven't seen it.
Of course they will. So there's no legal requirement for them to sign it. You need to have 2 copies. You need to have a copy for yourself and a copy for them. And what I normally say with contracts is give them the contract and tell them to take it home. Do not let them sign it in front of you, because what are they going to say? I was pushed into that. I was under duress. There was nothing I could do. Give it to them, email it to them. Would you take this home and bring it back tomorrow? Or when you've had a chance to look at it. If you don't get it back, send them an email or write to them. And what they're saying is that if somebody travels from work, and Lee, this is really important for you, domiciliary care, the amount of claims that I've seen, where they go from one home to another and they're not being paid for it because that's not working time, is wrong. It's unbelievable, that's wrong. So if you have a business where, and Grace as well, your fitters are going from A to B, that's working time, yeah? And if they're going from A to B, they should be paid for it. And the question that people generally ask me is, well, do I have to pay them from, if they're home workers, where they are to their first appointment? No, you don't have to pay them from where they are to their first appointment, because if I was employed and I worked in London, that's my choice. I don't have to pay them for it yet. I think it might change. I really think it will change.